Never a dull moment with those folks.
Sorry, I messed up the files a little bit.
Oh, you're totally fine. Oh, no, I did not. Okay, great.
Okay, let's go on the record for the 1:30 hearing. Graham, this is Graham versus Kay. This is file number 2514689. If I could have both counsel put your appearances on.
Nick Houghton, Michigan Auto Law on behalf of
the
Jake Danielewski, I represent.
Jake Danielewski, I represent this case.
All right, thank you. We're on the record today for a status conference in this case. Mr. Houghton, on behalf of plaintiff, can you tell me where things are at and what we need to do in terms of scheduling going forward here today?
We have mediation on Thursday.
Mediation on Thursday.
Paying all the money.
Sorry, you're a little garbled there. I heard mediation is coming up on Thursday?
It is.
It is.
Okay, all right. So did you guys want to, adjourn this today and reschedule it for a date following that mediation?
I think that'd probably be the best move.
I would agree.
Okay, all right. So do you want me to, Mr. Houghton, from your standpoint, should I go ahead and set this for next month? Do you want me to set it further out, the next status conference?
If we end up with a mediator's number, we'll probably need 21 days from that minimum. So why don't we set it for a month or two out? But I am going to be out of the country. Let me just look at my calendar quick, Your Honor. So I am out the week of the 23rd until March 4th. So anytime but then, Your Honor.
Okay. Mr. Danielewski, do you have any objection to that?
None, Your Honor.
The 23rd is Monday, and that would be your motion.
Okay, so we'll set this out to avoid those dates and for another status conference. If you're able to mediate and reach an agreement, then notify the court and we can take that status conference down as long as we have the closing documents prior to that. And if not, then that gives us the next date. Mr. Houghton, anything else I can address for your side today?
No, Your Honor, I appreciate your time.
Mr. Danielewski?
No, sir. Thank you.
Okay, thank you. That's all for today. You're both free to disconnect at this time.
Thank you. Have a good day.
Okay, Ms. Anderson, are you able to hear me okay? Ms. Anderson, are you able to hear me okay?
Your Honor, good afternoon.
Your Honor, good afternoon.
Okay, thank you. Mr. Morrison, if you're there, I need you to unmute and turn on your camera, please. Ms. Anderson, both the Morrisons are connecting right now, so it might just take a second here.
Well, thank you.
Well, thank you.
All right, Mr. Morrison, are you able to hear me?
Yes, I can.
Yes, I can.
Okay, and now we have Ms. Morrison connected, so we'll go on the record in Morrison versus Morrison. This is file number 2514907. The record should reflect both parties are present by Zoom video. We have Ms. Anderson, you're appearing on behalf of Ms. Morrison, is that correct?
That is, yes.
That is, yes.
Okay, so the last time we were on the record was back in November. At that time, the court ordered discovery to remain open for 60 days and for the parties to participate in community mediation. Ms. Anderson, can you tell me the status from the standpoint of your side?
Yes, Your Honor, I've been unable to get a hold of Mr. Morrison via phone. Mediation is also unable to get a hold of him. I did send him a letter before the holidays. Mr. Morrison, did you receive that?
Morrison, did you receive that?
Yes,
Yes.
Okay, in that letter, I did ask
In that letter, I
that
did
he
ask
contact
that
me
he
so that I
contact
have
me,
a means
so
of
that I have a
communication
means
with
of
him.
communication
My
with him.
understanding is
My
via mail,
understanding is
we're
via
sending mail
we're
to
sending mail to
the marital home, but
marital
Mr.
home,
Morrison's
but
living elsewhere, so then we
Morrison's
have to
living
wait for
elsewhere.
mail to be
everything I'm-
delivered. It's just not
everything
been
I'm
very
hearing is a big
Everything
seamless
I'm
echo.
hearing is
process.
a big seamless process.
Mr. Morrison, hold on one second. We can only have one person talking at a time, and I'll give you an opportunity to respond, okay?
Yes,
Yes.
Please finish, Ms. Anderson. What were you saying?
Essentially that when, even with
Essentially that
mailing
when, even with
him, I'm
mailing
mailing
him,
to the marital
I'm
home where
mailing
he's
to the
not
marital
currently
home where
residing
he's
during
not
the
currently
due to
residing during
criminal bond
due to criminal
conditions.
bond conditions.
So that mail also
So
needs
that
time for
mail
forwarding.
also
So
needs
we
time
don't
for
have a
forwarding.
great
So we
path
don't
here
have a
for
great path
communication,
here for
unfortunately.
communication, unfortunately.
Okay, Mr. Morrison, what is it that you wanted to say?
everything I'm hearing is just a
Everything
big
I'm hearing is just a
echo.
big echo.
I can't understand what
I
she's
can't
saying.
understand what she's saying.
Okay, Mr. Morrison, have you been contacted by the mediation service?
I don't know.
I don't know.
She sent me a letter.
She sent me a letter.
Okay, have you tried to reach out to contact her in response to the letter?
No.
No.
Why not?
When I tried to contact her,
I tried to contact her.
it wouldn't let me
Wouldn't let
telephone.
me telephone.
What wouldn't let you telephone?
The phone wouldn't go
The
through.
phone wouldn't go through.
That would have been correct
That would
during
have
the
been
holiday
correct
period.
during
Your
the
Honor. Our
holiday
phones
period.
are
Your Honor, our phones
automatically on do not disturb.
automatically on
I
do
don't
not
have the
disturb.
ability.
I don't have.
You can leave a voicemail, but I don't have the
leave a
ability to
voicemail, but I don't
leave
have the ability.
that
to
issue is
leave
no
it.
longer
That issue is no longer
in place, so he
in
may call me
place,
now.
So he may call me now.
All right, Mr. Morrison, did you get any communications from the mediation service?
No.
No.
Okay. All right, so I'm going to contact the mediation service on behalf of the court to try and have them set up this mediation because I think that's something that needs to happen here. Ms. Anderson, when they contact you, obviously you need to communicate with them. Mr. Morrison, when the mediation service contacts you, you need to follow up with that communication, okay?
Your Honor,
Yes.
if I could clarify
If I
something.
could clarify something.
I have
Sure.
already contacted mediation services and given them a copy of your honor's pretrial order. The issue is the phone number we have for Mr. Morrison. It rings, but you're unable to leave a voicemail. So there's no way to contact him by phone. So mediation has attempted to call him, to no avail, just as I have attempted to call him multiple times, no avail. So the referral to mediation has been made. We just need a phone number for Mr. Morrison where he can be contacted.
Okay, Mr. Morrison, do you have a phone number that you can give us? That's a good number that you will answer?
Yes,
Yes,
231
231
564
564
8919.
8919.
Okay. All right.
I'm also getting an echo. Was that 8919?
8919.
Yes, and I'm getting an echo
Yes, and I'm
also.
getting an echo also.
Okay.
So am I.
All right.
Mine.
So I'm going to have my office contact community mediation. We're going to provide that number to them to contact you, Mr. Morrison. So when they contact you at that number, you need to follow up with that. Okay.
Yes,
Yes.
Okay.
I'm actually going to provide that
I'm
to
actually
them
going
right
to
now,
provide
Your Honor,
that
via
right now,
email,
Your
because
Honor,
they're
via
waiting
email.
for me to
They're
provide them
waiting
that
for me
number,
to
but
provide them that number, but
Okay. That's fine.
thank you.
All right. And
thank
then
you.
I'm going to set this for another hearing following that mediation. If the parties are able to reach an agreement, then we can finalize things at that time. And if not, then we can set it for a final hearing before the court for an evidentiary hearing on any issues that remain. Ms. Anderson, anything else from your side?
No, that's it for us, Your Honor.
No,
Thank
that's
you.
it for us, Your Honor. Thank you.
Mr. Morrison, do you have any questions?
well, I'm not allowed to get a
Well, I'm not
lawyer
allowed to get a lawyer
because I got a
because I got
domestic
a
violence pending,
violence pending,
which we are going
which
to
we are
jury
going to
court
jury
because
court
I think I'm not
because I
guilty.
think I'm not guilty.
So I can't get a lawyer.
So I can't get a lawyer.
Why is that preventing you from getting a lawyer?
Well, I can't, I don't have any
Well,
money.
I don't have any money to get a lawyer.
Okay. So
She
the
has one
domestic-
for
how is
free.
She has one for free.
Okay, well, if she's going through Northern Michigan Legal Services, then you can also, seek to get counsel as well. There's no reason why the domestic violence charge in and of itself would prevent you from getting a lawyer.
That's what they told me.
That's what they told me.
I don't know who they are, but there's no reason why you can't have a lawyer in a divorce case because you've been charged with domestic violence.
Who should I call?
Who should I call?
I mean, I can't give you legal advice or what to do, but you have every right to obtain your own attorney.
Okay,
Okay.
So the court will send out notice of the date and time of that next hearing. Again, both sides, when you're contacted by community mediation, both sides need to follow up with that so that we can get that scheduled and get that heard. That's all for today, and all parties are free to
Right.
disconnect. Thank you.
Ryan,
Your Honor, I
Your
have
Honor,
spoke with
I
mediation.
have spoke with mediation.
Miss Morrison,
Yeah,
you have a lawyer. Your lawyer is the one who's speaking for you at this hearing, so
I'm sorry.
you can talk to the
I'm
lawyer
sorry.
about any questions you have.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. All parties are
Thank
free
you.
to disconnect at this
Thank
time.
you.
thank you.
Thank you.
looks like there's someone here for Tuttle right now.
Okay, I'm gonna record and grab my stuff for that case.
think that's my one.
Okay, Mr. Tuttle, are you able to hear me okay?
Yes, sir.
Yes, sir.
All right, thank you. We're on the record now in Tuttle versus Kalkaska County Road Commission. This is file number 2514686. The record should reflect that counsel for the plaintiffs, Mr. Tuttle, is present by Zoom. We have counsel for the Road Commission, Mr. Tunthus, present here in the courtroom. This is set for defendant's motion for summary disposition today and a status conference. So I'd like to proceed first with the motion for summary disposition. I did have a chance, Mr. Tunthus, to review your motion and brief and the exhibits that were attached to that, along with your reply book brief to the plaintiff's response. Mr. Tuttle, I did get your response and I had a chance to review that as well.
Thank you.
Thank you.
So I guess, and in looking at, I think both sides have accurately cited the law that applies here. And, you know, the real question is whether or not under a C10 motion, whether we have questions of fact that would need to be determined later at a full hearing before a fact finder, or whether this has been reduced essentially to a matter of law. One of the things, and I'm going to ask Mr. Tunthus as the moving party to do this first, but Mr. Tuttle, I'll certainly get your input as well in response. I know the parties have submitted a number of different drawings, you know, surveys and so forth, and I have a fairly good idea of, you know, the basic layouts of where the lots are and where the easement is. What's less clear to me from the drawings, and it's certainly not for lack of trying by both sides, just sometimes, you know, you all have been living with this. You've had sat down with people and have them go through these drawings with you. I'm looking at it as an exhibit. Sometimes it's a little bit harder for me to parse out what's what and where things are in relation to each other. And so I'm a little bit relieved to see that it looks like maybe there's a board here.
Yes.
So I guess my main question that I want to ask before I have the parties get in, or the lawyers get into your arguments, is I really want to understand where the drain field would be in relation, not to the roadway. I don't, for purposes of this point right now, I don't care where the actual roadway is, but where the bounds of the deeded easement are in relation to the drain field. So I'll give you first shot at that, Mr. Tunthus. Do you have a drawing of that, or is there something that you can?
I do.
Okay.
I do. That was the reason I wanted the in-person hearing, Your Honor, so that I could address that issue, because I think it's seminal. I mean, it's dispositive.
All right.
So,
If you can kind of set that up so that Mr. Tuttle
of course,
can see that as well.
of course,
Best you can.
I brought with me blow-ups of two exhibits that were attached to our motion papers that come from the deposition of their retained experts. Wesley Morey, the guy who's going to install the drain field, and Robert O'Brien, who's their engineer. The area shaded in yellow here is the highway easement. That's the incinerator lot. It runs over the incinerator lot. It's in yellow. You can see the carriage lane, and I'll talk about this a little bit more during my presentation in chief. That's the traveled portion of the roadway. That's what the tires touch. You can see East Bear Lake Road sketched in the highway easement, but rights of way, which is what a highway easement creates under Michigan law.
But, and I don't want to get into the right of way argument
Yeah.
either. What I want to know is
Sure,
the actual meets and bounds surveyed,
this is, yeah,
property description of that easement is that
that-
rectangular
that's
yellow
correct.
area.
That's correct. And I had Wesley Morey circle an initial where he would install the proposed septic field, and it's right there. Okay, it's within the highway easement.
Okay.
It's
So-
within the right of way.
And I don't want to keep interrupting you.
No,
but
that's
the
okay.
Entire incinerator lot is within the
Correct.
described meets and bounds of the dedicated easement,
The dedicated easement is 40 feet wide, correct,
all right.
which is wider than the carriage lane.
Even though the road itself doesn't comprise that entire.
Correct.
Okay.
Correct. Then we had engineer O'Brien do the same thing, and he actually drew more of a, I don't know what you call it, a trapezoid, some kind of a shape, but in the exact same area. He said the septic field's going to go right here. It's still within the easement, still within the right of way. And so I'll set this here.
By the way, I can't see anything he's
Wait, I
saying.
can't see anything to say.
Why?
Okay, maybe can you just point that out and kind
Sure.
of hold it up?
This is the area Wesley Morris circled and initialed in his deposition, right here.
Doesn't.
Is there a deposition exhibit that you can refer to for Mr.?
There is, it's deposition exhibit number 4 from Maury and deposition exhibit number 6 from O'Brien. Those are in the corner.
Okay,
And these are exhibits that were attached to our motion. I just blew them up because I know that it's easier to see it when it's blown up.
all right, so Mr. Tuttle, you know what exhibits he's referring to, you have those?
I have a huge, you know,
I
there's
have a huge, you know,
no shortage of paper.
shortage of paper.
I likely have them
I
somewhere,
likely have them somewhere.
not at hand.
Okay, these
Not
are,
at hand.
deposition exhibits that you've seen before.
May I respond to your question, Your
May I
Honor?
respond to your question, Your Honor?
My question is, are those deposition exhibits that you've seen before?
Likely, yes.
Likely, yes.
Okay. All right, go ahead. Did you have another thing you wanted to respond to?
May I?
Yeah,
Yes.
Well, Your Honor, would you go to page,
Your Honor, would you go to
page 6 of our opposition
page
brief?
6 of our opposition brief?
You'll see there's a survey there,
See, there's a survey there,
and the incinerator lot
and
is
the incinerator lot is
plainly shown
clearly shown
in relation to the actual
in
roadway.
relation to the actual roadway.
And you can
Okay.
see there's
There's
a-
a,
down southeast corner,
down southeast corner,
there's a lot of open land, and
there's
that's
a lot of open land, and that's
where the Elgin Field is
the
proposed,
open field is proposed,
not intersecting with the
not
roadway.
intersecting with the roadway.
Right, and I think that's reflected in exhibit 6 there.
Yes, this is effectively from that same sketch. That's
Okay.
exactly right.
Okay, so I understand, Mr. Tuttle. Yes, I see that open area in the southeast corner. That's kind of the trapezoidal area that you're referring to, Mr.
Correct.
Toompas. Okay. So I understand your position, Mr. Tuttle, is that it's within the incinerator lot, but it's not touching or within the area of the traveled portion of the roadway.
Correct.
Correct.
Okay, thank you. All right, so that clears up my question to start with. So that you both have answered that. I appreciate that.
Yeah.
So now, Mr. Tunis, I'm just going to turn it over to you for your oral argument on your motion. And then once he's done, Mr. Tuttle, I'll give you an opportunity to respond.
Thank you, Your Honor. So I wanted to preface this by talking about the C10 standard, because Your Honor brought it up at the beginning of this hearing. There are no genuine issues of material fact in this case. And that was pretty clear to me once I started taking the depositions of Maury and of O'Brien. And I'm listening to Mr. Tuttle right now. Everybody agrees where this thing is going to go, prospectively. The question is, what are the road commission's rights? What's the difference between the right-of-way and the traveled portion of the roadbed surface and the legal framework? So the real questions that predominate are questions of law, not questions of fact. And it's a C10 motion. There are no genuine issues of material fact. And so I wanted to start by talking about the difference between the right-of-way and the carriage lane. Easements for highway purposes create a right-of-way. That's what Michigan law says. A right-of-way is different than a roadway. There's a whole section of the Michigan compiled laws, the county road law, that talks about what a road commission is, what a right-of-way is, our permitting authority, when we have to issue a permit, under what circumstances we may issue different kinds of permits, so on and so forth. And the case law is a layer of gloss that covers that statutory framework. We cited it in our brief. We've done a heck of a lot of briefing on the issue of highway easements in this case. And the general thrust of the law is this: the right-of-way is broader than the carriage lane. Why? Because the right-of-way is actually a community space over which my client is the sole custodian. We get to decide who comes into the right-of-way to install something. We get to decide who can work in it, under what conditions. And it's because the right-of-way is a community space. It is in the parlance of property rights, it is a bundle of rights that my client holds in trust for the public, the motoring public, the general public. And the carriage lane is almost always narrower. Even when you're talking about these super highways, like state highways, it's always narrower than the right-of-way, because roads need to be engineered and you need space on the sides for ditching, for culverts, for drainage, for reinforcing the space that's going to create the actual traveled portion of the roadbed. But there are other reasons too. Utilities have a right to place their installations in the right of way. The drain commissioner has a right to work within the right of way, subject to certain conditions. This is a community space, fiber optic cables, telephone lines. These folks aren't trespassers. They're allowed into that community space, and we're the custodians of that space. So the carriage lane is different than the right of way. Here's why this matters. When you have a user road, or you don't have an instrument of conveyance, the presumption is that the right of way is 66 feet wide. It's 4 rods. That's the turn of phrase. And it's measured on 33 feet from dead center. Here, we have an instrument of conveyance. There was a written easement for highway purposes that created this particular right of way. And it says it's 40 feet wide. It covers the entirety of the incinerator lot. So we're working with less space here, but we're working with more space than the actual carriage lane, the traveled portion of the road. Their whole argument that this septic field is not interfering is because they don't understand. And I get it. This is a niche area of law, by the way. I've been doing it for 15 years, but before I started, I had no idea the difference between the road and the right of way. I understand it's not common knowledge. They don't teach classes in road law, on road law in law school, but there's a difference. And so the idea is they say it's not interfering because there's all this free space. We're not touching where the tires currently go. End of discussion. And that became, again, really clear to me when I was taking their testimony. Number one, I learned this isn't going to go under the roadway. I thought it was based on their pleadings alone. It's going to go into a berm off the side in the area that Maury circled in initial. That's where he's going to put it, a berm. Their septic field is going to go in a berm, and there are other parts that run in different directions, but that's where the main installation is going to be. And I said, okay, but that's in the right of way, right? And it was clear to me that they were blending the terms right of way and roadway. He said, no, it's not touching the roadway. And that's when you get into the hypothetical questions I asked them in their deposition. I understood, I'm not going to get these guys to agree with my definition of road versus right of way. They're not lawyers, but I also don't need to. Just tell me physically where you're going to put the thing. And the law does the rest of the heavy lifting. And they planted it right there. And I said, okay, riddle me this. In a hypothetical world, the road commission decides, as they're allowed to do under law, you know what, we're moving East Bear Lake Road. We don't like where it sits for drainage reasons. We have to widen it. For any reason under the sun, we want to move it within the right of way, which is their sole right to do. They decide they want to do that and they move it. Well, that's going to interfere with the septic mount, isn't it? And they said, well, yeah, hypothetically, we don't agree with you that the road and the right. I understand that. I understand that. I understand. But if they have to widen the road or they have to move it, given where you've placed it, that's inconsistent. Yeah, I agree with that. And we cited that on page 18 of our brief. Both those guys said it, Maury and O'Brien. And I said, this really, to me, is not a controversial proposition. I understand you disagree with me as what the law means, but this is in the easement. Yeah, I agree with that. And if we have to move it, there's inconsistency. Yes. John Rogers, the road commission's managing director, explained the exact same thing. Look, if we've got to widen this road or pave it or improve it or do something with it, there are minimum widths we have to deal with. And we're going to need more space than the road as it's widened or moved. And we're going to need the entirety or a larger chunk of the highway easement than is currently touched by the footprint here, as is our right to do. And that's going to be an inconsistency. Here's why this matters. That consideration, Your Honor, respectfully to the other side, is enough to have us win this case. It is in the highway easement. It is inconsistent. It's consistent right now with the current footprint of the road on January 6, 2026. And progress doesn't always move in a straight line, but it always moves in one direction, forward. And the likelihood in 3 years, 30 years, 300 years that road is never going to need to be touched or moved or paved or reinforced is unrealistic. So it's enough for us to win. The case ought to be dismissed on that reason alone, where they placed it and their admission that it's inconsistent with the right of way, if the right of way is what I say, as opposed to what they say. Okay. But more importantly, this isn't some hypothetical question. 3 years ago, there was a special assessment district that people had proposed where they wanted the road paved, expanded, that would have required us to do the exact same things that would make this septic field inconsistent with the highway easement. And by the way, I got those documents from Bud Banker. The township, I don't live around here. I don't have a finger on the pulse of local history, but I was put in touch with Bud Banker. He said, oh yeah, there was a special assessment district. It died on the vine because the guy who was pushing it passed away. But he said, I suppose that somebody could pick up the torch just as easily and run with it. Here's the thing. I was on a Zoom call with this court 8 or 9 months ago, the first time we moved for summary disposition. And Mr. Tuttle looked into the camera and said with a straight face, there are no plans. There's no plans to do anything. They're making that up. You know what? You look at the email chain of people who knew about that special assessment district, you see a lot of Tuttle names on it. This is something they know about. This isn't hypothetical to them either. So here's the thing. You have a proposed septic system that is smack dab within a right-of-way. You have our managing director saying, look, if we need to move that road, widen it, improve it, any of those rights that Michigan law says adhere to highway easements, rights of way, there's an incompatibility. You have their retained experts saying the exact same thing, granted under the guise of me telling them what the law is, but that's okay. They say the same thing. They circle, they initialed in the drawing. It's right there. And you have the reality that that's enough for us to win. That's enough to decide this is inconsistent. But moreover, there is a very good chance that these improvements are going to need to know or need to happen in the future, and they know about it. We're the custodian over this public space. We have the solemn obligation to make sure that those rights are protected for the motoring public and the public at large. We cited this in our brief as well. Even if we thought this septic field was a great idea, or we just got tired of this fight and said, you know what, I'm sick of coming to court, fine, have your darn septic field, have a great life. We couldn't do it because those rights are held for the public, not individual property owners. And the second they signed that highway easement and created a right-of-way, things changed. Things changed. So, Your Honor, for all those reasons, there is no genuine issue of material fact. There is a law, and it's pretty clear, Supreme Court authority that goes back 60 or 70 years and says rights of way, highway easements are rights of way. The right of way is more broad than the carriage lane. This is smack dab within the right of way. We think it would be an impediment. They admit it would be an impediment under our understanding of the law. And on top of it, the cherry on top, there were plans to have a special assessment district 3 years ago. We win. It's that simple. This case has to be dismissed with prejudice. If this court has any questions, I'd be happy to answer them. If not, I'll take my seat and let Mr. Tuttle talk.
No questions at this time. Thank you.
Thank you.
Mr. Tuttle?
Well, let's examine the state
Let's examine the state
that there's going to be a
that there's going to be a
conflict if they widen.
conflict if they will.
He imputes that to our experts,
Introduce that to our experts.
Mr. O'Brien. Let's look at
Right.
page
Let's look
11
at
of our brief.
page 11 of our brief.
Yes, Mr. Moore, I want you to
Yes, Mr. President, I want you to
assume for purposes of this
assume for
question,
purposes of this question.
planted in the area that you
Area that you
circled. This is now
circled.
highway.
This is
for
now
purposes.
highway for
Are you with me? I am.
Are you with me? I am.
The Elgin Field has to be moved
The
on
Elgin Field has to be moved
in
under
that circumstance,
that circumstance.
doesn't it? The answer is, I don't see why it would have to be.
I don't see why it would have to be.
And then on page 12,
Mr.
And then on
Tuttle,
page 12.
Mr. Tuttle, I hate to interrupt you, but your voice isn't coming through real clear. I don't know if you can move the microphone or the device closer to you.
Right.
I just want to make sure we're making a good record. that's
We're
all.
getting feedback.
We're getting feedback. And
I don't know, maybe that'll
I don't
help.
know, maybe that'll help.
I'm not a computer.
I'm not a computer.
And I don't know what to do to stop.
I don't know what to do to stop it.
Let's see, audio,
Let's see, audio.
noise is on, okay,
Noise is on, okay.
now it's,
Now it's,
I don't know.
I don't know.
I can't seem to stop.
I can't seem to stop.
Yeah, your voices are just going in and out, so I can hear a little bit of what you're saying, but not everything.
Yeah, I tested the speak.
I tested the speak.
The
The
video is on.
video is on.
Yeah, no,
No.
No, I cannot figure
No,
out.
I cannot figure out.
What's that?
Yeah.
I'm afraid to hit too many things.
Afraid to hit too many things.
Yeah.
Um,
My speaker's on. I don't
my
know
speaker's on. I don't know.
what else I
We
can
haven't
do.
had this problem in the past with hearing, our other hearings, we haven't had this problem, so I don't know if there's something different in the setup that you guys have.
No, it's the same computer.
No, it's the same computer.
I don't know why it's doing this.
Why it's doing this.
I wish we could have been there in
I wish
person.
we could have been there in person.
Would have made it easier.
Would have made it easier.
No.
I believe you could have. I believe that my office indicated that you didn't want to come in person, so.
Well, we thought it was Zoom. I just
I
finished.
thought it was Zoom. I just finished.
He said everything's Zoom.
He said everything's Zoom.
Well, do you want to reschedule this where you can be here in person?
It's, if we can.
If we can.
Sure.
Sure.
We have exhibits
We have
too,
exhibits too.
and pictures. There's
And
houses.
pictures. There's houses.
Well, okay, Miss Tuttle or whoever, it's okay for you to be involved in talking about the computer and the
Yeah.
technical parts, but it turns,
Well,
the
I'm
rest of it, I
just-
need to hear from
I'm
Mr.
just
Tuttle.
Can we reschedule it? So we
Can we reschedule it so we can?
Your Honor, can I,
Yes.
I'm not trying to be difficult, but we noticed this to take place in person. There was a back and forth of about 6 or 7 emails between your assistant, myself, and Mr. Tuttle yesterday. He used the phrase, "I object to this hearing happening in person," and was told that it was noticed to be in person. You can come any way you want. He chose to do it via Zoom for whatever reason. I will say this. I would like to take a stab at having him talk into the microphone because we haven't had issues before. And if there are continued issues, I would leave it up to this court's discretion to do what it will with respect to the hearing. But their claims absolutely fall apart at even the slightest brush. And I drove 2 hours to be here. I would just assume like to go forward if that's at all possible.
All right, let's give this one more try. Mr. Tuttle, maybe if you can get as close as you can to the microphone, even if that means that the video isn't as good. Let's see if that helps. And
I'm close.
I'm close.
okay, go ahead with your argument.
He
He
made the statement that the
made the statement that
eligibility would be an impairment.
would be an impairment.
I invite your honor to look
I invite your honor to look
at our experts.
at our experts.
True.
True.
If you look at pages 10,
If
11.
you look at pages 10, 11, are brief.
He asked Mr.
He asked Mr.
Maury that, and he said
Maury
no,
that. He said no.
no. And
No. And
let's start with what we
let's start with what we can
disagree with. First,
disagree with.
the commission has
First
no
of all,
plans
it has no plans
to widen or improve East Fair Lake
widen or improve East Fair Lake Road,
in the area of the incinerator lot.
the area of the incinerator lot.
Proven twice in our brief
Proven twice in our brief
with their admission request
with their admission request
and with Mr. Rogers' testimony.
and Rogers' testimony.
Mr. Rogers has never
Mr.
admitted
Rogers has never
to Elgin
admitted
Field.
in Elgin Field.
We have no testimony from
But
anybody.
no testimony from anybody that's
Ever seen an Elgin Field.
or seen an Elgin Field.
Park.
Or,
Furthermore, this was all
furthermore, this was all
approved by the health department.
approved by the health department.
Mr. Rogers admits that.
Rogers admits that.
Mr. O'Brien testified.
Mr. O'Brien
Also
testified.
an expert. He said,
Also, he said,
you wouldn't even know the Elgin Field is
you
there.
didn't know the Elgin Field is there.
There's no ditching.
There's no ditching.
There's no proposed septic
There's
system.
no proposed septic system.
It's imaginary. That's a
It's
fiction.
imaginary. That's a fiction.
Whatever.
Whatever.
There'd be no impact on East Fair.
There's no impact on East Fair.
That's on page 12 of our brief.
That's on page 12 of our brief.
And
And
there's no ditching, and this
there's
special
no ditching, and this special
is
is
irrelevant, as I said in our motion.
irrelevant, as I said in our motion.
If you widen East
If
Bear
you
Lake
if
Road,
widen East Bear Lake Road,
knock down some of the houses.
knock
along
down
the
some of the houses along the
road would be in their
road would be in their
front yard or their living room.
front yard or the living room.
There's no way that they're gonna
There's
widen.
no way that they're gonna widen.
And Mr. Rogers admitted.
And Mr. Rogers admitted.
What I want to thank the court to is our brief, a point of Michigan law that told us an easement does not displace general possession of land. It's the quotation at the bottom of page. Grants the holder of the easement only to the extent necessary. Covered by the easement. Hackman, 1872. They have no plans. Bear Lake Road. And this special assessment never went anywhere. It was in Sunset Shores.
Which is
Subdivision north of East Bear Lake Road. And where East Bear Lake Road dead ends. So there is the record is rich in evidence that the placement of an Elgin field on the incinerator lot is compatible with the road commission. It's conspicuous by its absence. Is any evidence emanating from defendant that any of their rights? All argument. We've come forward with a great amount of evidence. Two experts. And admissions of the road commission. They have no intention of widening. In the area of the incinerator lot. And one thing we've cleared up is the road commission. Not issue septic permits. That's the health department. This was all good with the health department. And only Mr. Rogers has defeated to play Bigfoot step on it. So there is a wealth of evidence in the record here on the justiciable issue before the court. It is whether the installation of an Elgin field on the incinerator lot compatible with the road easement for highway purposes. In view of this conflict with the evidence, motion should be denied. Thank you, Your Honor.
All right. Thank you, Mr. Does any brief comments in reply?
I do, thank you, Your Honor. Couple things. First, this contention that we have no plans to improve East Bear Lake Road in the area of the incinerator lot. Well, that's true, but it's also irrelevant. The question is whether it's within the right of way, and the explanation is important this way, Your Honor. It's coextensive with our permitting authority, right? Let's say they need a permit, and here's why the health department alone isn't enough, because this would go in a public road right of way, not on private property, in a public road right of way. We don't have to allow them to put this here. We don't have to plant weeds, so we force ourselves to pluck them down the road. There's no obligation, there's no letter in anywhere of Michigan law that says a governmental agency has to do something it thinks is unwise, because in the current instance, its wisdom is an open question. And then they have to wait until a situation is bad before they step forward and remedy it. So what do? We permit the septic field, and then in 15 years, somebody decides to reassess or go forward with the special assessment district. And that forces us, by the way, special assessment districts are citizens coming together and saying, you may not want to improve the road. We're going to put up the money and make you improve the road. And we have to do it. That's forcing our hand. Right? So let's say we just decide in 15 years, you know what? The traffic count has gone through the roof. That subdivision to the north is grown even more, and we just want to pave the road. Well, if we're going to pave it, that means we got to move your septic mound because now we need ditching. Now we need to be wider than however many feet it is now. What do? Do we go back into court? Do we have to go back into court to pluck this weed that we never wanted to plant? No, we don't. The law doesn't require a government agency funded by tax dollars to do that. It leaves it up to our discretion. We are not obligated to permit their sewage in the middle of a public roadway. That's preposterous. And it's not enough for them to say this pile of sewage in the current instance is not touching where the tires go, so it's a resolved question. No, that's not how it works. That's not how the law works. The right-of-way is broader than the carriage lane. And it's page 18 of our brief where I asked both of these guys in their deposition. I said, Mr. Moore, in this hypothetical where you've installed the septic field in the area you've circled on Exhibit 4, and it turns out that that's in the county road right-of-way, and they're going to widen East Bear Lake Road. You acknowledge that there would be some incompatibility between the septic field and the road in that instance, right? Some incompatibility, yes. Okay, that's a guy with a 10th grade education. That's how straightforward this proposition is. It's in the right-of-way. If we do anything to the road, it's going to need to be moved. Their engineer, who's got a lot more education than me, said the same thing. Mr. O'Brien, so if that's the case, this was my question. So if that's the case, and the road is widened beyond its current footprint, that will bring it into conflict with the septic field, right? Yes. Yes. You agree with that? In that hypothetical world? Hypothetically, yes.
Didn't say that.
Didn't say that.
Mr. Tuttle, I mean, you're well aware of how arguments work. We don't interrupt other lawyers. I'll give you an opportunity to speak, okay?
Yes, sir.
So,
Yes, sir.
Your Honor, whether or not we've ever seen an Elgin field, whether or not we have plans to widen the road is irrelevant. What the health department thinks is half of the equation. The rest is our permitting authority because this is in a county road right-of-way. Your Honor, there is no question of genuine material fact that this is a rank, obvious interference with this road right-of-way. And we don't want it. This case should be dismissed for all those reasons. Thank you.
All right, Mr. Tuttle, you wanted to reply?
Yeah, I wanted a citation.
I wanted a citation where
he says Mr. O'Brien said
he
those
said Mr. O'Brien said those.
record, and he didn't say those.
Record, and he didn't say those.
Manufactured quotation.
Manufactured quotation.
Okay. All right, I'm going to ask everybody to remain. Mr. Tunis, if you can remain here in the courtroom. Mr. Tuttle, if you can remain connected. I need a second. I'm going to roll from the bench on this, but we're running into my 2:30 time, so I need to take a couple hearings and then I'll recall this case in just a few minutes. So Mr. Tuttle, I'm just going to mute you for the time being, and then we'll recall the case. So please stay connected. Thank you.
Thank you.
Thank you.
Would you like me to move?
No, you're fine. Everything's online. Okay, we'll go on the record in Maxwell versus Roddy. And this is file number 25-14948. If I could have both counsel put your appearances on the record, please.
Good afternoon, Your Honor. Elena Lund. Well,
Good afternoon, Your Honor. Jonathan Tomas on behalf of the plaintiff.
Jonathan Tomas on behalf of the plaintiff in this matter.
Thank you. All right, this is set for a status conference today. I know the parties at one point did have a motion up, but it sounds like that's been resolved. So in terms of a status conference and some dates for going forward, Ms. Lentz, I'll address you first as attorney for plaintiff. Can you tell me where things are at and what you'd like to see for scheduling going forward?
of course, Your Honor. Attorney Tomas. I'm so sorry. The feedback is very strong on my end. We've been talking some of it already and exchanging initial figures. Engagement was helpful. we still need to exchange our demographic financial information form.
Okay, how much discovery would you like to have in this case?
I think 60 days would be
I think
sufficient.
60 days would be sufficient.
Okay. All right, Mr. Tomaso?
I would agree 60 days would be appropriate.
60 days would be appropriate.
All right. Ms. Lance, in terms of mediation, is this a case that's appropriate for community mediation? Are we dealing with a large marital estate with a lot of assets, or is this something that would be more appropriate for community?
There is two pieces of real estate, and the parties have labored life, and so there is a bit of division between premarital and marital assets. So I think it's best to use a mediator that is also an attorney.
Okay, Mr. Tomaso, any objection to that?
I'm sorry, there's been a lot of feedback. Was
Sorry, there's
that,
been a lot of feedback. Was that
private mediator, Your Honor?
private mediator, Your Honor? Because that's what I would suggest.
Okay, all right. And if we set a deadline for mediation within 90 days, any objection to that, Ms. Lentz?
No, Your Honor.
Mr. Tomaso?
None, Your Honor.
Your Honor.
Okay, so the court will order that discovery to remain open for 60 days, mediation to occur within 90 days. I'll ask counsel to confer an attempt to agree on a mediator. If you're unable to agree, notify the court. If you do agree on a mediator, then please notify the court in writing of your selection. And then I will set this for a status conference at about 90 days. If the parties have been able to reach an agreement, then we can use that date to take proofs and enter a judgment. If not, then we can discuss setting it for a final hearing for the court to determine, or further ADR, or however the parties want to proceed. Ms. Lentz, any other dates that I can address for your side today?
No, Your Honor. Thank you for the time.
Mr. Tomaso?
Not at this time, Your Honor. Thank you very much.
Thank you very much.
Okay, so I'll send out a pretrial order that reflects what we've discussed today. The court will also send out a notice for the date and time of that next status conference in about 90 days. Again, if the parties are able to resolve it and we want to use that date for taking proofs, if you can submit a judgment prior to that hearing so the court can sign it at that time. Otherwise, all parties are free to disconnect at this time. Thank you.
Thank you.
Thank you.
Thank you.
Take a short break and then we'll come back on the record.
All right.
Okay, we'll go back on the record now in Tuttle versus Kalkaska Road Commission. So I just needed 1 second to go through a couple things there. First of all, number one, this was set for oral argument in person. It's my understanding, based on discussions with my staff, that Mr. Tuttle was objecting to having to appear in person today. And so, you know, to the extent we've had communication problems, certainly there was an opportunity to appear here in person, as Mr. Tuntas did. Regardless, I was able to hear most of what Mr. Tuttle said. I think everything that Mr. Tuttle was arguing here today on the record was consistent with what was in the brief, as was Mr. Tuntas' argument. So other than the court being able to view some larger versions of exhibits that were put in briefs and depositions that both sides had access to, there hasn't been much argued here in oral argument that wasn't argued in the written briefs of the parties. So I don't find that there's any prejudice and any communication problems that we've had here in the court. I think it's fully versed in the arguments of both sides. And because they are so consistent with what was in the written briefs, I'm comfortable with ruling here on the record today. First of all, addressing the standard that the court's employing under MCR 2.116C10, as both sides are aware, that is a motion for summary disposition on the basis that there's no genuine issue of material fact, and that the moving party is entitled to judgment as a matter of law. The court is to consider all documentary evidence that's provided by the parties, deposition transcripts, and so forth. I have reviewed all the exhibits. I did read the deposition transcripts that were submitted by the parties, and so the court is relying on all of that as its basis for its ruling here today. If the court finds that there is no genuine issue of material fact, then the court should grant summary disposition. Looking, and whether or not to grant summary disposition is something that's within the discretion of the court. Moving first to, I think, just some general principles, and I was glad to hear Mr. Tuttle cite a case from the 1800s, because I'm going to cite one myself that covers kind of just some general principles involving easements and the relationships of easement owners and fee owners, and that's Harvey versus Crane 85 Mich 316 1891, which is the owner of a fee subject to an easement may rightfully use those lands for any purpose not inconsistent with the rights of the owner of the easement. The rights of the owner of an easement are paramount to the extent that they're within the bounds of the grant of the easement. Those rights are paramount to the owner of the fee. In other words, the owner of the easement has priority in terms of their use of the easement as long as it's within the scope to any uses that the owner of the fee might want to put to that property. What is considered proper and reasonable use by the fee owner versus unreasonable or improper or inconsistent with the easement owner is generally a question of fact. So I'm starting with the proposition that as the fee owners, the Tuttles can rightfully use their lands and that incinerator lot as long as that use is not inconsistent with the rights of the road commission, which owns the easement. The rights of the road commission to use that easement are paramount to the rights of the Tuttles as long as they're using that easement within the dedication, which is for highway purposes. The Tuttle's use, as long as it's not inconsistent or unreasonable, is again not a legal question, it's a factual question. So I'm looking at it from that standpoint. I did review the Ide Brothers case cited by Mr. Tuntas. I thought that was an interesting case. It certainly laid out the bounds or the scope of a highway easement or an easement for highway purposes. And it's clear from that Ide case that it goes well beyond the use for just a travel portion of the roadway, that the government can use highway easements that are dedicated for highway purposes for all kinds of things that aren't necessarily directly the travel of wheels over a roadway. And so the Ide case involved some drainage and so forth, but the Ide case cited to some earlier cases, the Cleveland case, which interestingly involved the government building a parking structure within a highway easement. Certainly not something that you would consider to be part of a traveled portion of the roadway, and wasn't, but the Cleveland case, which was relied on by Ide, held that parking was an appropriate use of a highway easement. And several other cases that included uses such as sewers, ditches, public utilities, sewer lines, telephone lines, gas, lighting, all kinds of subsurface uses that were found to be within the scope of a highway easement under Ide. The interesting thing about Ide was it was the exact opposite of what we're dealing with here, which is in Ide, it was what can the government use outside of just for travel, a highway easement, and how does that impact the fee owner's rights? In this case, it's the fee owners that want to use the area within the highway easement, and how does that impact the government's rights? So it's not directly on point in that sense. However, I do think it illuminates the scope of what the road commission could potentially be allowed to do within this easement. And I think that sheds light on then what would be a reasonable or unreasonable use, or a use contrary to those rights by the Tuttles. I don't think there's really any question of fact in this case at all when it comes to what is the easement itself. That's very clearly set forth. What is the purpose of the easement? It's for highway purposes. The fact that the easement takes up the entire lot. Again, the reason why I asked that question at the beginning is I don't even think I need to get into the definition of right of way or any of those things, because the easement is the entire lot. So what we call the right of way or don't call the right of way, that entire lot is reserved for the use of highway purposes. And that's by the language of the easement itself. So I don't think I even need to get into this argument of right of way versus traveled portion of the roadway or any of that, because the meets and bounds of the easement itself and the incinerator lot is all reserved per the language of the easement for highway purposes. So that means that conceivably the road commission could decide to construct sewer lines, water lines, gas lines, up to a parking garage, if you follow the Cleveland case, within that area, and that use would not be inconsistent with the Tuttle's rights as the fee owners. That all of that would be considered proper uses for highway purposes of that easement. And so what that says to me is, whether there's anything in that berm area, that trapezoidal area, that vacant area that's not within the traveled portion of the roadway, whether anything's there or not, at any point, the road commission could decide to put something there, and their rights are paramount to those of the Tuttles. And if there's a septic field constructed in that area, then that septic field would have to give way to whatever the road commission was going to put in there. And so for those reasons, I find that, and I think the testimony of the witnesses pointed out by the defendant, the defendants, the road commission in this case, clearly establishes that that septic field would be in the way of anything that would be constructed within that easement for a highway purpose. And I think common sense says that, if that road is straightened, the road commission needed to put anything, ditches, sewers, telephone lines, gas lines, water lines, anything within that area, It's within the easement, it's dedicated for highway purposes. A septic field is going to interfere with that use. And as I stated, going back to Harvey versus Crane in 1891, anything that's inconsistent with the rights of the owner of the easement, which are paramount, is not going to be permissible. So the court finds that there is no genuine issue of fact here, based on the testimony, based on just, again, common sense that that area is within the easement. Anything that the road commission would need or want to put in that area would be interfered with by a septic field. And so the court finds that the defendants are entitled to judgment as a matter of law on that basis. And Mr. Tuntas, I would request that you prepare an order reflecting that ruling of the court today. That would be a final order that resolves all the remaining claims. And because that's the ruling of the court, I don't find that there's a need to proceed with the status conference. There isn't any further scheduling that would need to be done. And so, Mr. Tuntas, I would just request that you'd submit that order under the 7-day rule.
Very good, Your Honor. Thank you.
All right, thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you, Your Honor. Have a great afternoon.
All right, thank you.
Thank you.
See that the parent versus short. All right, Mr. Baranski, are you able to hear me okay? You're muted, sir.
Yes, I can hear you very well.
Yes, I can hear you very well. Now, hopefully you can hear me.
I can, thank you. I'm not seeing Mr. Popovitz. I've got a number of other attorneys in the Zoom waiting room. I'm not sure who else might be appearing on his behalf in this case. Have you been dealing with any other attorneys from his firm on this file?
No, I have not.
No, I have not.
Okay. Well, I'm going to bring them all in and let's see who's who, I guess.
That's the only way.
That's the only way you can do it.
All right, Mr. Conlon, which case are you appearing on?
Yeah, I'm appearing Taylor Olmsted versus B&K NIST.
Yes.
Okay, Mr. Deegan, which case are you appearing on?
I'm on Eagleson versus Dollar General or
Dolgan Corp.
I'm getting some feedback here. Pretty good.
Yeah, we've been having that problem today. I don't know, maybe it's something on our side.
Right.
I've had it with some attorneys and not others, so.
Hey, Mike Conlon and Don
Bransky. Jack?
So, Mr. Deegan, I have yours
Yeah,
at 3:30. Did you want to sign back in later?
Oh, sorry about that. I will. Judge.
I will. Thanks, Judge.
Okay, sounds good. Thank
Good
you.
afternoon, everybody.
Good afternoon, everybody.
And Mr. Conlon, I'm going to call your file in a minute. I'm just looking for. No, that's not Mr. Popovitz. All right, so I don't see Mr. Popovitz, Mr. Baranski. I don't see anyone else that would be appearing on that file. I do have this set for a scheduling conference today. Did you want me to reset this? Do you want to forge ahead? What are your thoughts?
Why don't we reset
Why
this?
don't we
This is a
reset
case
this? This is a case
of a land contract
of a
between a
land
brother and a
contract between a
sister.
brother and a sister.
Brother says, I paid
Brother
off. Mom
says, I
says,
paid
I mean,
off.
brother,
Mom says, brother.
I mean, sister says, I paid,
Sister,
no, you
sister says,
didn't.
I paid, no, you didn't.
So it looks like it's
So
probably
it
just
looks like it's probably just
paper,
paper
trail.
trail.
All right, I'm
So
gonna reset
maybe
that.
we should reschedule
Maybe
this.
we should reschedule this.
Yeah, I'll reset it for another status conference. If nobody shows up for the defendant at that time, then we can discuss how to go forward to keep things moving.
Outstanding. Appreciate it.
Outstanding. Appreciate it, Your Honor.
Okay, thank you. You're free to disconnect at this time.
Thank you. Hey, have a good day, Your Honor.
Have a good day, Your Honor.
Thank you. And then Mr. Conlon, I've got Mr. Kroll signing in on your file here. Mr. Kroll, are you able to hear me okay?
I am. Good afternoon, Judge.
Yeah, good afternoon, Judge.
All right, good afternoon. Okay, so we'll go on the record in Umstead versus Manistee Campgrounds. This is file number 2514943. If I could just have both counsel put your appearances on.
Tom Kroll for the plaintiff.
Kroll for the plaintiff.
Michael Conlon for the defendants.
Conlon for the defendants.
Thank you. We're set for a pretrial scheduling conference in this case. Mr. Kroll, can you just tell me a little bit about your claims here and what you would like to see for scheduling going forward?
Your Honor, it's a
relative.
I'm getting a feedback. If your clerk would like to mute themselves,
so there's no
double.
Yeah, we've been having this problem. I'm not sure what's going on. I've got everything set up the way I normally do, so I apologize for that.
Oh, don't apologize. You're the
Don't
judge.
apologize, you're the judge.
But it seems that you're logged into two devices. Have overlapping audio.
Yeah, as far as I can tell, we don't have anybody else logged in, so I'm not sure.
So there's one main
view,
and that's covering the courtroom. And that's up in the corner. And I'm guessing that's up there. It is. Okay, you got it, Judge. Good job.
That's better on my end.
That's better on our end. But I don't think we can hear you now, Judge.
Yeah.
That's fine. I'm gonna let you guys talk. What you have to say is more important anyway. So
there
you can both address. I'm gonna mute myself because we have something going on in the courtroom that's causing the problem. So I'll have to work on that later, but I'm gonna mute myself. And if you guys can just let me know what you would like again for scheduling going forward, and we'll try and limp our way through this.
Certainly, Judge. Thank you. So what we have here is a premises liability complaint. There was I believe it was an air conditioner unit that was right in a walkway out of a restaurant. My client struck it, and he suffered injuries to his head and neck, and that's it's closed head injury and a neck injury. So. As far as discovery, I'm open to whatever discovery the court needs. It's a very straightforward premises liability case. I could probably show you a picture and you can understand it better.
Okay, Mr. Conlon, what kind of timeframes would you like in this case from on behalf of defense?
Yeah, I would like kind of the normal discovery time would be 180 days. And then, that would be the main thing, would be that 180 days for discovery. I have not received, one thing I would ask is I haven't received initial disclosures yet, so I'm sure Tom's got that forthcoming. But with my schedule already kind of booked up, that's why I'm asking for 180 days. I'm not disputing it's probably not that complicated of a case. But yeah.
Okay, so if we set this for 180 days discovery, if we have mediation within that 180 days, and then typically what I would do is set this for a status conference at the close of discovery, to see where things are at. If the parties weren't able to agree in mediation, then we can discuss whether we wanted to do any further ADR or whether we just want to go and get it on the trial track and get it set for trial and go that way. The only other thing is I typically would set a dispositive motion cutoff, motions filed within 30 days after the close of discovery. Mr. Kroll, any objection to that?
I have no objection to whatever you laid out.
Okay, Mr. Conlon?
No objection.
Objection.
Okay, so then I will set this for a status conference at about 180 days. We'll do that by video. Hopefully it'll work better than the one is today. The only other question I have, Mr. Kroll, do you think that you and Mr. Conlon would be able to agree on a mediator?
We may.
May.
Hey, Judge, if you'd like to mute.
Hey, Judge, if you'd like to mute.
For way background, I will only agree to a retired judge. I've been using Justice David Viviano, former Supreme Court Justice. He's very conservative, probably one of the more conservative judges in the state. I don't know why a defense would object to him. Judge Dan Ryan and Judge Dan Hathaway. Now, Judge Dan Ryan and Judge Dan Hathaway, those are Wayne County judges. A lot of people object to those folks. But I will agree to a retired judge, Your Honor. So if the defense counsel would agree to that, I would agree to that. If you have a retired judge that you might suggest.
Yeah, that's highly unusual to me. I've never heard another attorney say that. I will, I'm not going to stipulate that I'm going to agree only to a retired judge. If there's a retired judge, I think my client would be fine. I would do that, but I'm not going to absolutely not stipulate to that.
And the reason
being is that
that's fine. I don't need to necessarily know the reasons, but the pretrial order provides that the parties are to attempt to reach an agreement. If you're not able to, then notify the court. If you are, then notify the court in writing as well. But that'll all be spelled out in the pretrial order that I'll send out to the both of you, along with the dates that we've discussed here today, and the notice of hearing for that next status conference. So Mr. Kroll or Mr. Conlon, anything further for?
I have sent my initial disclosures. I believe we've even filed the witness list with the court with certain requests for admission. They were sent probably back in November 12th of 2025.
I'm sorry, I didn't mean to interrupt. I haven't received any pleadings from your office. I'd asked the court to have him resend those because I haven't received anything.
Okay, well, that will be well, I'll email everything to you today.
Thank you. Yeah, appreciate that. If you do that.
We sent everything on the 12th of November.
Yeah, I did not. In fact, I specifically asked my legal assistant if we received anything, including the initial disclosures, and she said no. And so, yeah, I'd appreciate it if you emailed that out. Thank you.
Mr. Kroll, or for both of you, I mean, for the record, they did make it to the court file. So I'm not sure why they didn't get to Mr. Conlon, but Mr. Kroll, if you can make sure that he does have those documents.
Certainly.
Okay, thank you. That's all for this hearing today. You're both free to disconnect. Thank you.
Thank you.
Thank you, Judge.
Thank you. Hey, Judge.